I had somebody call the office and ask if there was a way to submit questions during the show where I could just answer them on the air. And my secretary asked me that, and I said, tell them to call. So that's really the easiest way. I don't have any way, you know, I'm not constantly checking my email or text messaging or anything during the show. This is live radio. If it were like a seminar or a webinar or something like that, it'd be a little bit different. But because we're doing live radio, it really doesn't work out for me to kind of try to stay focused on that. So the best way to do it is if you have a question, it's 888-344-1170, 888-344-1170. That is the station studio line, and you will be getting Noah. He'll answer the phone. He'll put you on a brief hold until he can tell me who you are, and then we will pick it up and ask your question. I'll let you ask your question. You don't have to give your real name to me on the air. You can make up a fake name or whatever. I would love to hear your questions though, and be able to field them on the air. If it's something that I cannot answer, then I will defer, not deflect, but I will defer, and we'll figure out a way to get your situation taken care of. So 888-344-1170. If you have questions regarding taxes, that's going to be the second hour of the show, and the first hour of the show, estate planning. What happens when what happens to kids when parents die? I guess the interesting thing, the most colorful thing about what my practice has involved as an attorney for 30 something years doing this is how colorful people are, and how people deal with the messiness of life and the beauty of life, and how it's just interesting how everyone has a very kind of their own perspective on things. And no matter how much you study and read and all that, you have this perspective, this vision, this understanding that actually changes through time. And it's not wrong to have that happen. It just does. Part of it is growing up, maturing, getting new information, understanding that things have changed. There's just a lot of that happens. And so many people just kind of realize eventually that their life has changed and things have changed. And I think the older people get, the more they realize that you can just kind of accept things, kind of like, nothing I can do about that, and it's not going to affect anybody horribly, so let's just leave it.
Yeah, so things are always changing, and especially when you're talking, taxes and things like that. Mm-hmm. We actually have a question today from Robert, and he's in San Diego. He's got a question about the gift tax, Gary.
All right, Robert, welcome to the show. This is Gary Quackenbush. How you doing, man?
I'm doing fine, Gary. Thank you so much for taking this.
Sure. What is your question, Robert?
Well, as you said, it's the gift tax. First of all, I'd like to know a bit of history on it, the rationale behind it, why it was instituted. And then I have a specific question to see, am I having given a gift over to my daughter, its repercussions? Could you address that?
Well, I can't tell you why it was instituted. I have no idea. Probably because we're trying to get some, I don't know, probably because the government needs money to function. But I don't know. I don't even know the background of the gift tax. I know it's been around for a long time. The way it does work is there's a reporting requirement and there's a payment requirement. So, and that's where we have to kind of realize there's a distinction. So the main rule is if you're a U.S. citizen and giving money to another U.S. citizen, and if the amount of money that you're giving is less than $15,000 or is
2 minutes
$15,000 or less, it doesn't get reported. It's not taxable. It doesn't get reported. You don't have to tell anybody about it. Once it's above $15,000, then it has to be reported on a gift tax return. It's a 709. Okay. So for example, if you had, 10 people that you wanted to give gifts to, and you gave them all $15,000, that $150,000, it's not reported. It doesn't go anywhere. It just, you give those gifts. All right. And this is cash or asset value and all that thing. Once it's over $15,000, you're supposed to file a gift tax return. The giver is supposed to file that return. Now, once you file that, so let's say the 10 people, you're going to give them each $20,000. Well, the first 15 doesn't get reported, but now there's 20. So you've got to report all of it, deduct the 15, and 5 of each of those gifts. So in this case, it's going to be like $5,000 or what is it? $50,000.
Hold them over if you have to.
That goes against your what we call lifetime gift credit. Okay, so the lifetime gift credit is equal to the amount of money that you can inherit without tax. So like right now, the lifetime gift credit is like about $12.6 million. So you can give away in your life, Robert, you can give away $12.6 million and never have to pay any taxes. You'll have to report it on gift tax returns, but you don't have to pay any taxes. So if you're giving more than that, it'll be taxable by the giver, but not by the recipients. Does that help?
So what you're saying then is I have to keep track of the total of the cumulative value of my gifts over my lifetime.
That exceed $15,000 per person. Yep. You keep track of that.
Right.
Yep. And if you give too much, you pay a little tax on it. So then you get
specifically.
Okay. All right. So I'm going to have to hold you over to continue to answer your question. You're listening to The Word on Wealth. This is Gary Quackenbush. We're talking to Robert. We'll be back after a brief break back here on The Word on Wealth.
You don't need to know everything
Nice.
to know where to find answers you can trust when you need them. Welcome to The Word on Wealth with Gary Quackenbush. We're here to help you build, protect, and transfer everything you've worked hard for with expert estate planning, trust administration, inheritance, and probate. Call Gary and the team at gqlaw.com, 855-500-TRUST.
You're saving and investing for the future, and that's good. Have you ever stopped to think, where does my money actually go? This is Faith-Based Investing with Anthony Wright.
Most Christians just don't understand that the money they save for retirement usually helps fund the abortion industry and other liberal anti-family causes. But did you know that with just a few minutes of your time, we can screen and clean your investments at no cost to you? It's absolutely complimentary. Just go to the website right now, download a free copy of my book, Faith-Based Investing. It's free as well. You deserve to know the truth as the investor. Then the choice is yours. You can keep doing what you're doing, or you can line up your investments and life savings with your beliefs. We are fiduciary investment advisors. You can feel good about investing with confidence. So learn more now. Go to BibleSafeInvesting.com or call me at 931-RETIRED. Your free book is waiting for you. Go to BibleSafeInvesting.com and be sure that you listen to Faith-Based Investing this weekend right here on Family Talk.
So Gary, we've talked a long time about estate administration. So what is that and why is it important?
Estate administration is the distribution part of estate planning. So when someone passes away and they leave money to beneficiaries, the property has to be administered. So it's like taking it from the decedent to the survivor. That's called the estate administration process. So usually you're going to have a successor trustee that's named in the trust. So have no idea what they're doing because they've never done it before. So then they call on GQ Law and we walk them step by step on how to be a successful and good successor trustee. We also do the required notifications. We notify the Department of Health Services and all the legal requirements so that they can have the estate administration done properly. We help successor trustees be successful.
Call or click to request your free consultation. gqlaw.com, 855-500-TRUST, gqlaw.com.
Who will you trust with the biggest financial decision of your lifetime? If you're planning to buy or sell a home in San Diego County, do what I do and work with the true San Diego real estate experts. Ken Pecos and the Pecos Group helped me and my family. They can help you. This is Gary Quackenbush of The Word on Wealth. You hear Ken every week here on The Word on Wealth. He's our expert. He's got integrity, exceptional service, deep knowledge of the San Diego, Coronado, and South Bay regions. These are just some of the reasons that Ken Pecos has completed hundreds of transactions. He manages a powerful team of professionals at the Pecos Group. From single-family attached homes to luxury high-value waterfront properties to apartment buildings, Ken Pecos is ready to help you avoid problems and costly mistakes. Learn more online at kenpecos.com. That's Ken Pecos, Pecus.com. Or call 619-977-8419.
DRE number 010566969, brokered by eXp Realty.
What aren't we being
friend about this broadcast outreach. The Word on Well with Gary Quackenbush of GQ Law. Call or click to request your free initial consultation or to talk with a member of the team. Call Gary at 855-500-TRUST. GQLaw.com.
You're live.
All right, you're listening to Word on Wealth. So good to have you along. If you've got questions, we do have lines open. 888-344-1170. We're talking about estate planning, trust administration, and we are still on the phone. Robert held over during the break. Thank you, Robert. We're talking about the gift tax laws. So we got the summary that you can't give away more than a $1.6 million in your lifetime. You got to keep track of that. And that number doesn't decrease or doesn't get credited against until that any gift to any person exceeds $15,000. So there you go. Any other questions on that,
Gary,
Robert?
you're saying 1.6 million. I thought you said 12.6 million earlier.
12.6.
12.6, not 1.6.
It did not change over the break. 12.6.
Oh, okay. 12. Okay. Now, in actual example, a few months ago this year, I bought a car for my daughter, pretty much paid out of pocket on my own. It was over $30,000. Is that considered a gift then? Eligible? And
what did you gift it to her? Is it in her name now?
Yes, it's in her name, registered in her name. She didn't have the money. It was basically a gift to her.
Yeah. So technically, if it's a gift that exceeds $15,000, then you're supposed to file a gift tax return saying that you gave a gift of over $15,000.
That's a Form 709, you said. And I submit that with my tax return. And basically, I would owe, if it's a $30,000 car, do I pay tax on the, let's say, the difference of $15,000 then?
Okay, let's go back over that. You don't remember what's the dollar amount that you can gift without paying any gift taxes? It's $12.6 million.
Right.
Right. So you give her a $30,000 car, $15,000, that's $15,000 over the gift limit, the reportable limit. So technically you're supposed to file a gift tax return to say that you gave a $15,000 gift to your daughter, and it's not taxable yet because you still haven't exceeded the $12.6 million. And you just keep track of that for the rest of your life. It's like,
exactly. That's the case. It's like keeping track of IRA contributions on the 8606 form. You have to keep those good records so that in case there's ever an audit, you're covered.
Yeah, technically, but we don't. Yeah, technically. You're right.
Okay.
Yep.
Gary,
that's the law.
Some great advice.
You're welcome.
Thank you so much.
All right. Thank you, Robert, for being part of the Word on Wealth. Appreciate you calling. Robert is a longtime listener. I recognize his voice, and he's asked some great questions in the past and helped the show along. So I appreciate that. Let's move a little bit. We're talking about, what happens. I had somebody ask me, what if a beneficiary cannot be found? And by that, I mean, example. So we had a life insurance policy, and it was to pay out, and we're doing the part of the trust administration. Somebody passes away. We got to figure out what to do with the trust. So we're looking at that. Ran into a life insurance policy, and there were 5 people on the life insurance policy. One of them was the long lost son, like long lost because he had become homeless, I don't know, a couple of decades before, and nobody really knew where he was. So the thing that happens there is the life insurance company says, well, I've got 5 beneficiaries. Who, where are they? Show me, who they are. So basically the 4 living beneficiaries are the 4 that we knew of. They contact the life insurance company, which is the way you do it. And they provide proof of death, which is then the trigger to have to make the payment. And 4 of them were able to prove who they were. Now, the 5th one, if you read the beneficiary designation, it says, when I die, I want one, here's my 5 beneficiaries, 1, 2, 3, 4, 5. And then you had to have a contingent beneficiary. So if one of them were dead, then the 4 would receive the money. That's the way this one was set up. Well, the 4 that were getting the money, they could not prove that their brother died. And so the brother couldn't even disclaim it or do anything because they couldn't prove that he'd passed away. So they we're pretty sure that he was alive somewhere. And then we ended up hiring a private investigator to try to figure out, where this person was. It was very interesting because if you hire a private investigator and you find out that somebody is actually homeless and they're like attached to a shelter, the homeless shelters have to provide privacy. Okay. There's this privacy concern. They can't talk about who's in there. They always, they kind of, I don't know, inventory, but they keep track of who is in a shelter. That's totally normal. And they are not allowed to disclose that information. So the problem you run into, even if you were pretty sure that's where your brother was, if you contact the homeless shelter and say, hey, my brother's there, I think, and we need to give him a check for $200,000. First of all, the shelter will not even tell you whether that person is there, because if they say, no, he's not here, well, that's a disclosure. Or yes, he is here, that's a disclosure. So they can't even say, it's like one of these, we can neither confirm nor deny. So they basically say, because of privacy rights, we cannot tell you whether or not the person that you're requesting is here. So that makes it really difficult. Sometimes you have to get a court order to say, to basically say it's not a violation of privacy. You do it in confidential. There's a bunch of ways to do it. But it was very interesting to me to see that, because you'd think the shelter would say, oh, wow, yeah, he's here. Let me get him on the phone. But they can't do that. If you were living in an encampment somewhere and you went in and said, hey, is Bob here? Then that might be a different story. I'm just not sure you'd want to do that. But that was the thing. So to answer the question, what if a beneficiary cannot be found? If you cannot establish that that beneficiary has died, that money is held in reserve for the beneficiary. This is whether it's going to be a beneficiary of a life insurance policy, it's going to be beneficiary of an investment account, beneficiary on a trust or a will. That money will stay unspent in the trust until you figure out, we can't prove whether that person's dead or alive. That money then typically will be given to the state of California into the lost property. And they say, we don't know where this guy is. We don't know if he's dead or alive, but here's this money and we don't have anything to do with it. The reason you would do that is because as the successor trustee, remember what your job is. We talk about this all the time. Your job is to figure out who the beneficiaries are, give them proper notification, and distribute the property. So if you've done the best you can to give proper notification, which may be, publishing the notice of death, publishing the notice of intent to distribute in a local newspaper, which would include the homeless brother that, technically he's been given notice, that's one way to do it. But as far as giving the homeless brother, the brother that we can't find, as far as actually giving them the money or just saying, well, we're just going to pretend like he's dead, I'm sorry, you can't do that. As the successor trustee, you cannot legally, in good conscience, say, yeah, we already know he's dead. I mean, you got to provide proof so that you can do that distribution. So if you can't prove it, that money goes to the state. It doesn't get spent. It gets put into this state recovery fund. And that's where you can go online. If you look up, there's lost property. The state of California and a lot of other states, most other states keep track of it. And you can put in the name and social security number of a person and find out what money is it, like for you, you put in all your information and you can find out whether there's any money being held for you. And a lot of times there's going to be rebates that you didn't claim, or a refund that you didn't claim, or something was delivered somewhere. And, there's just a bunch of different ways, but that money, that life insurance policy, it's going to either be held by the life insurance company or they're going to turn it over to the state and say, we don't want to hold on to it. It's considered lost, like lost property. Interesting, right? So that was, I always, want to know too, the thing I've had people ask, like, well, what if they're disinherited? If they're disinherited, dad put in there, no money goes to this particular person. And whether you enumerate reasons or not, it doesn't matter. That person has been disinherited. Because they're named in the trust, you have to find them. Because I'll have people that'll do that. They'll say, well, I don't want my ex-wife getting anything. So
well, here's just a little bit of a question. What if somebody tries to find them and they're unsuccessful? Let's say, I don't know, even extensive period of time goes by, it's been a year and a half, they cannot find this person.
Then if they cannot prove that that person died, then that money's going to go to the state of California. It's just going to sit there. It'll just sit there for a long time, decades. Because this is big fund that California has. It just sits there.
This is why, I mean, you talk about it so often, but this is why you have to appoint the right people.
Yeah, appoint the right people. And if if you're setting up your estate plan and you realize you have a beneficiary that you have no idea where they are, I say change your trust. Don't leave them money because it's just going to be tied up. Or maybe you want to, but I think it's just the understanding that if they cannot be found, money doesn't just, you don't just send it to the last known address. They have to be available to receive the money. So yeah, it is just a really weird thing, but that's why you get these people. Sometimes you get these people that will, they find money for you and then they'll notify you and say, hey, if you sign this document here, there's funds, we think there's funds available, and we can't tell you anything about it other than it's money that we found, that we believe that you're entitled to it. And if you want to have us tell you where the money is and how much it is, then sign this document and we get half. Well, those things, some of them they're scams, but most of them are not. And we had Consumer Bob telling us about that when he actually did a story with it on NBC, where he was saying that, yeah, they're legit. I mean, they're legitimate companies that do that because they'll find all this money that's cheated or gone to the state and it's just sitting there, and they'll do the genealogical research and find out, well, once that person actually does die, then it's supposed to go to that person's heirs. So these people will go and search out and they'll find out that, your great uncle passed away and left his estate basically just sitting there. And so now you're entitled to, 126th or something of this huge big estate. So sometimes those people, they find these, hidden treasures or lost property or unclaimed property is what it's called. Then unclaimed property, sometimes you can go and figure out that it's really for you, or if somebody contacts you, you just got to be careful. I'm not, advocating, but it's like, they're not all scams. Sometimes people find unclaimed property and they actually do determine it's from, for you, or you have the right to it. And if you just say, well, forget you, I'm not going to pay you, well, then you'll never figure out the property because, it's not illegal what they're doing. It's totally legitimate. It's money you had no idea that you're entitled to, and maybe you're entitled to. Anyway, side note, this show has got a lot of side notes. You're listening to The Word on Wealth. This is Gary Quackenbush. If you want help getting your estate plan together, will, trust, power of attorney, in dealing with the, after maybe your parents have passed away, your loved ones have passed away, and you're trying to figure out what to do, like what's the next step? If dad passes away or mom, and there's still the other one is still around, like, is there something you need to do? That's the kind of stuff we talk about. And I'd be happy to meet with you personally, and we'll talk about what to do and, just kind of discuss options. 855-500-TRUST, 855-500-TRUST. If you don't have an estate plan put together, or if you have one that you're not happy with, call me. Let's fix it. 855-500-TRUST. We'll be back on The Word on Wealth.
You've got questions. We've got answers. This is The Word on Wealth with Gary Quackenbush of GQ Law. Gary's here to give you peace of mind with expert estate planning, trust administration, inheritance, and probate. Call Gary to build, protect, and transfer your wealth. 855-500-TRUST. GQlaw.com. Gary and the team at GQ Law, 855-500-TRUST. Or go online and download Gary's free ebooks and videos. Read Gary's blogs. Call or click to request your free consultation or to talk with a member of the GQ team. That's gqlaw.com, 855-500.
You're live.
Welcome to the Word on Wealth. This is Gary Quackenbush. Rich, how you doing?
Good. Great to be here.
Oh man, it's always good to be here on air. I love it when Rich comes in because then when he's in studio, it's just easier because we have more to talk about. I don't have to be so boring. So Rich is an associate attorney. He works with me at GQ Law. His thing is that a lot of stuff what we've done with Rich is taxes, tax issues, tax controversy. IRS or the government is chasing somebody around trying to get their money for good reasons or bad, whatever. We're dealing with it. That's Rich's baby. And I thought, one of the things that we talk about, and Rich has kind of enumerated options, like if you owe a bunch of money to the IRS, then, there's options that we talk about, right? Payment plans. We talk about currently not collectible. We talk about offering compromise. And then a lot of times they're saying, and don't forget about the option of bankruptcy. As far as the eliminating taxes possibility. In fact, Rich and I have on our website, gqlaw.com, there's a book. It's a free book. It's called The Tax Bankruptcy. If you go onto the website, gqlaw.com, it's a free book. It doesn't, automatically file you for bankruptcy or do something weird. It just downloads a PDF. If you click on the book cover, it's orange, and it talks about, different types of tax problem resolution options, as well as the bankruptcy thing. So I thought today, Rich and I were talking about, we should talk specifically, let's talk about bankruptcy, how it works, kind of the basics. So Rich, so let's start out with that is just initially, what is bankruptcy? Because people have these really different impressions on what it is. So talk about kind of basically what it is and what it does.
It's a federal filing either under two different chapters, Chapter 7, which would be a personal liquidation bankruptcy, and then a Chapter 13 is where you have some income and assets to pay off some or all of your debts over a 3 to 5 year period. That's called, again, a Chapter 13 plan. It depends generally on how much income you have and how much assets to whether you would be filing under Chapter 7 or Chapter 13. Chapter 7 is a complete liquidation where you're personally discharged from your owing on your debts and generally don't pay anything to creditors. Again, Chapter 13 is where you would pay some or all of your secured debts would be paid in full. Your unsecured would get some portion of their debt from 0 to 100 cents on the dollar.
Thank you. That's a good summary. So let's assume a lot of people just think, oh, bankruptcy, somebody has all this debt for whatever reason, and it wipes out their debt. So now they don't have any more credit card debts. And it just seems like, I don't know, I just seems like over the years, a lot of people think, bankruptcy is just this super easy way to get out from under your debt. It's a kind of this irresponsible thing, and everybody just does it because they just feel like getting rid of their debts. But I think the one thing that I wanted to go over a little bit was if you file a bankruptcy petition in the court, I want you to talk a little bit about kind of what's required, like what you have to disclose on that. It's basically like a book that you write, right? That you create, but what's disclosed on the petition? And then I want to ask you, are there things that you run into that are problems? Like you're going, oh, this, here's this problem, or here's something that comes up. Are there things that come up in bankruptcy that basically would be considered problems or trouble?
Well, on your petition, you would have to disclose all of your assets. That would be, your home, your cars, your bank accounts, your brokerage accounts, your retirement accounts, anything and everything that you have an interest in. Secondly, you would need to disclose your income and your expenses. And then you would need to disclose all your debts. You can't pick and choose which debts you want to discharge. Like you don't want to discharge Uncle Louie's loan that you said you'd pay him back on, but you do just want to discharge your owing to Citibank. So you have to disclose all of your debts. Generally, the best way to do that is to run your credit report and download that into your petition. That picks up most of your debts, does not pick up tax debt, does not pick up spousal support, an alimony and child support, but it does pick up the majority of your debts. But all those information does have to be disclosed. Then there's also a series
the
of
credit report won't pick up Uncle Eddie's debt, right?
no, it will not. It has to be
Any
any
personal debt.
creditor that would file. They has to report with the credit agency, and that's where we pull your. It gets a credit card debt. Sometimes doesn't include medical debt either.
Oh,
So
interesting.
again, with your attorney, make sure you review your all your Schedule E. D, E, and F, those are the creditor schedules to make sure that all your creditors are disclosed, because if they aren't disclosed on your petition, they could argue at a later date that their debt shouldn't have been discharged in the bankruptcy. Also, the trustee may say, hey, he didn't disclose all of his debts, so, maybe he shouldn't get his discharge. So again, you have to disclose all of your debts too. And then there's a series.
So now you mentioned trustee, because that was my thought, is like, well, you're supposed to disclose all of your debts, and there's ways to do that. You get a credit report, things that you've written down, things about of. But who is actually looking at that? I mean, it's like, does it get examined? Do people look at it? Who's the one that's actually trying to figure out whether it was done right?
Well, the U.S. trustee, which is the federal government, appoints local trustees here in the Southern District of California Bankruptcy Court. That's San Diego and Imperial County. There are 3 separate in California. There's a Central District for Los Angeles and Northern District for San Francisco and that area. And they appoint both Chapter 7 trustees. I believe there are 5 of them now. And then they appoint Chapter 13. There are 2 of those. Those people are they basically are sort of the watchdog. They protect the unsecured creditors in a person's bankruptcy. They are trying to find unexempt assets that they can seize and sell for cash, and then pay out the unsecured creditors some portion of their debt. So they're looking for equity in homes, equity in vehicles, unprotected bank accounts, things like that. They're sort of the watchdog that protects the unsecured creditors. Also make sure that the debtor does qualify for whatever chapter they're filing under.
Okay. So, and that's kind of so you have the U.S. trustee, which is that's a federal position, and the U.S. trustee has local trustees, Chapter 7 trustees or Chapter 13, who are really, that's kind of their charge to act on behalf of the U.S. trustee and trying to determine whether the petition was true and correct and all that. So I have a question on that. Let's say, I don't know, non-disclosure of debts is not that, you don't see that much. Most people want to get rid of everything. Talk about the other side of it. So you have to talk about your debts and your liabilities and what you owe. What other stuff do you have to disclose on the bankruptcy petition?
Well, there's a series of questions. They call them the Statement of Financial Affairs. I think it's 28 questions. It's kind of like a history over I would say the last 2 years. Did you transfer, major assets out of your estate? Like you gave a home to Uncle Eddie and for less than fair market value, things like that. Did you pay one creditor an excess amount over the last 90 days? That would be considered a preference where you're preferring one creditor over another. So that your where you've lived in the last 3 years, because if you didn't live in California consecutively for the last 3 years, you may not qualify for a California bankruptcy. So a lot of questions that you have to answer under the Statement of Financial Affairs. That's another big component of the bankruptcy petition.
And what about there's the part of asset disclosure too. Talk about that a little bit. Because the Statement of Affairs, that's kind of, that's such a funny. I remember when I first started, when I was working on a petition for the first time, I went, Statement of Affairs, that is the weirdest thing to ask people. And I remember early on in my career, I'd be talking to people, okay, you disclose all of your liabilities. That goes on the debt schedules, the secured creditors and the unsecured. And then people go, what's that? So we explain it. But then it's like, and then you need to fill out the Statement of Affairs. And it's like, what? It's like, no, that's not what I mean. It's like your Statement of Financial Affairs. Like, what have you been up to in the last couple of years? That type of thing. But in addition to the Statement of Financial Affairs is you also have to disclose all your assets, right? Talk about that a little bit before I break.
I think that's the one thing you do have to disclose all of your assets. I mean, if you're a beneficial interest in a trust, if you have you're a beneficiary of a life insurance policy, anything that you have that has some value could or potentially could have value, you need to disclose it on your petition.
Well, even like joint ownership. I mean, we've seen that, like, mom and dad decide, oh, this is my, my clever estate plan, and I don't want to have to do a will or trust. I'm just going to put my kids on title. That's an asset in the kid's name.
Yeah, you would have to disclose that as a trustor of the, I guess, is that the correct term of the trust? And if you've transferred that property within the 2 years of the filing of the bankruptcy, that may be considered a illegal transfer under the bankruptcy laws.
So interesting. So it's not just like this, as of the date of filing, this static thing that says, what did you, we're not looking at what you had yesterday, but what do you have today? We're looking back a year or 2 or 3 to see whether transfers were given away or somebody was paid off preferentially. I mean, isn't that kind of the thing with, so if you like
1 minute
paid a bunch of money to somebody or gifted some money to somebody, those sometimes are kind of pulled back into the bankruptcy, it's almost as they say, well, you gave it away right before the bankruptcy, so we're just pretending like that's your asset and that's part of the bankruptcy.
Yes, it happens quite often.
Interesting. This is Rich Mathurin and Gary Quackenbush from the Word on Wealth, or from the GQ Law, is a law firm that we run here in San Diego. And we'd love to have you ask us questions online. We've got lines open. It's 888-344-1170. We're talking about bankruptcy, how that affects, kind of the general idea of how bankruptcy works. I think it's fascinating. I know Rich likes it. So when we come back from the break, what we want to do is we're going to talk a little bit more. I've got some questions for Rich on, what problems do you see that come up with bankruptcy? Like, who fights about what? We're going to talk about that coming up next here on the Word on Wealth.
You don't need to know everything. You just need to know where to find answers you can trust when you need them. Welcome to the Word on Wealth with Gary Quackenbush. We're here to help you build, protect, and transfer everything you've worked hard for with expert estate planning, trust administration, inheritance, and probate. Call Gary and the team at gqlaw.com. 855-500-TRUST.
Gary.
You're live.
Right. Welcome to the Word on Wealth. This is Gary Quackenbush and Rich Mathurin, associates at GQ Law. We're talking today all about bankruptcy, everything you wanted to know. If you got a question give us a call at 888-344-1170.
Gary, I did want to interject one thing. You talked about people that didn't disclose assets. Please never do that ever on you're signing that petition under penalty of perjury. But in today's bankruptcy, there are a lot more. The exemptions for home equity are much larger than they were a couple of years ago. We can protect your car. If you don't have home equity, we can protect $33,650 under what they call a wild card. So there's a lot of protection for your property. You're not going to lose your car. You're not going to lose your dog. I mean, there's a lot of protections to protect your assets. I think we've talked about this before. It's about a fresh start. There's debtors' prisons were, outlawed in the 1700s. So they're looking to give you a fresh start. And with that fresh start, you need to have, a place to live, a car to drive. So there are a lot of exemptions allowed in today's bankruptcy.
So the idea, it's like, because of the exemptions, you want to disclose all of it and get it under the exemptions. I found that, and I believe you found that too, is that it is easier to help somebody that's willing to tell you the whole story. Because then you can say, well, we got to do this or talk about that. It's really hard to represent somebody who's thinking, well, I don't want to tell my attorney this. I don't want to tell my attorney this. I'm going to hide this because I don't want them to know about it. It almost seems like those are the ones where somebody else finds out, and it's probably going to be that trustee.
Yeah, you do have to. One thing to note is when the local trustees, the Chapter 7 trustees and the Chapter 13 trustees, they demand proof of all of your documents. They get your home equity, your home loan, your home mortgage loan, all of your bank statements, all of your pay stubs, and they have people in their offices that go through these things line by line. I'm sure they have access to the DMV records. They have access to the San Diego County Recorder's Office. So it isn't worth lying on your petition. It's going to come back to bite you. Please be upfront. If you're going to do your own bankruptcy, or if you have an attorney, please disclose it all to him or her so they can help you.
So the penalty for perjury, this is federal, because bankruptcy is federal. The penalty for perjury isn't it? It's 5 years in prison and $250,000 fine.
Yeah,
It's a big deal.
I do have a little disclaimer that I send out to all our clients when they're about the disclosures, that those are the penalties. So please, we can help you, but you need to disclose everything.
Yeah. And I think part of the help might even be like, you know what, this isn't going to work. We got to come up with a different option. Maybe there's too much equity or there's the risk. And I think going in and having that description of the risk, I know maybe you really want to get rid of this, or there's a creditor that's really coming after you hot and heavy, or you're trying to stop a lawsuit. You need an injunction, you need that kind of thing. It may be that you need that, but it may be that you don't qualify. So that's the one thing you're going to get, is honest opinion. Like, here's how it works. Here's some pitfalls. Here's some things to watch out for. But you want to get it right, because, oh man, if the U.S. the trustee comes after you and they find out you've done something wrong, there's a disclosure. And if it was an intentional disclosure, if it's an accident, there's a reason for it. That's one thing. But if it was an intentional disclosure, failure to disclose, that's a big deal. And what could happen is besides the money and all that jail time and stuff like that, it's like, then you could be barred from ever filing a bankruptcy. That's the one thing that I always think is that, I don't know, it's scarier than going to jail, but it's like you would never be able to take advantage of a bankruptcy, even if you got yourself like in really, really super hot water. Talk just a little bit about the kind of the immediate.
Hey, real quick, Gary, before you move on, we do have a caller.
All right. Who do we have?
We have Tom from Ramona.
Tom from Ramona. This is Gary and Rich on the Word on Wealth. Welcome to the Word on Wealth. How are you doing today, Tom?
Great. Thank you. Very well. Gary, I have several songs that I've written. I've only made like $1,000 off of them, but I'm wondering how you place something like that in your trust.
In a trust, that's a good question. Because it's an asset, then it depends on how it's held. But what you do is you list it, because it doesn't. If you're trying to say that, you mean like the right to the song, like
exactly.
Did you trademark it or copyright?
Yeah.
Yeah. So you can assign copyrights to a trust. It's a form that we put together. And we have to, if it is copyrighted, then you have some documentation, and we can assign that copyright, it's a form that'll say assignment of copyright, and then, that I assign copyright number, just fully legally describe it to the, Tom's Living Trust dated such and such. So it's an assignment of that copyright. And then because that puts it in the trust, then your trust can decide how to distribute it, whether it's just like it goes in equal shares to beneficiaries or to a particular person, but it's been assigned to the trust, assigned for administration under the trust.
Okay, great. Thank you.
You're welcome, Tom. Thank you for calling. And we have lines open also here on the Word on Wealth, 888-344-1170. Calls with questions regarding taxes, bankruptcy, estate planning. We're here to the top of the hour. The number is 888-344-1170. Okay, so we were talking about, we're having a discussion on like what to watch out for. And what I was thinking, Rich, was help people understand, like, if somebody's being chased around by the IRS or the state or a creditor, how does it work? Like, how much relief can you get? Like immediate relief? Talk about the automatic stay and those things.
Yeah. Once we file your case, and that's done with a couple of presses of buttons, the bankruptcy court issues a notice of filing, and what's called an automatic stay is put in place by the bankruptcy court, bankruptcy laws. That means that any creditor cannot take any involuntary action, whether it's calling you, trying to foreclose on you, suing you, anything like that. They cannot do that, but through the bankruptcy court. They have to try to get what's called a relief from the stay for reasons that I don't want to get into now, but that they aren't adequately protected or whatever. But they have to do everything through the bankruptcy court, so they can't do anything immediate. They can't levy your bank account, garnish your wages, type of thing. So that automatic stay is put in place, and all creditor things have to be dealt through with the trustee and through the bankruptcy court to try to get their claims paid. Again, that's why the Chapter 7 trustee is appointed to try to find assets to pay that creditor's debt in some way. Again, as we mentioned, all creditors have to be disclosed on your petition. They can't refuse to be put on or anything like that. Everybody's listed, and again, it's up to the bankruptcy laws whether their debt is discharged. I have found that, fraud or anything where a creditor's debt hasn't been discharged is very, very rare. The bankruptcy courts are very, very debtor friendly.
Yes, absolutely. And I think that's when, like Rich is saying, when you file a bankruptcy petition, if there's a lawsuit, it will stop. It puts the brakes on the lawsuit. It may have to be litigated later, but it puts the brakes on things so you can get this automatic stay. It's an injunction. It's like a super fast, super powerful injunction, stops everything. It may be temporary, but at least it gets you some immediate relief and an immediate stop. So if you qualify, maybe you'll be in a Chapter 7, eliminating your debts. Maybe there's going to be some selling of assets, probably not. But then maybe you'll be in a Chapter 13 where you're doing a reorganization or something.
One other powerful tool of the bankruptcy, if you do have a creditor judgment that they've gotten a lien and they put it on your house, through a bankruptcy proceeding, you can get what's called a lien avoidance motion, that you would be able to take those judicial liens as a creditor liens, not tax liens and not your mortgages, but your judgment creditor liens. You can get those, what they call avoided in bankruptcy, Chapter 7 bankruptcy. Chapter 13, the term is a lien strip. That's where the property is underwater, and because of that, you can usually strip the junior liens on a property. So there are several ways to get rid of liens on your property through bankruptcy too.
And that's one of those things I think is a big deal. If you get a lawsuit against you and you end up filing bankruptcy, you have a home, you can protect the home with the exemption, but then also during that process, you can actually try to eliminate and potentially just wipe out that creditor lien. So you don't owe the debt, you don't have a lien, everything's cleaned up. You may have some credit issues. Really, is there a huge impact on people's credit?
It stays on your credit report for 10 years, but I have found that most creditors think that your person is a better credit risk after the bankruptcy than before, because they had this crushing debt before the bankruptcy. Then afterwards, they're discharged from it, and they have more available income to pay their debts. That you will be able to get to credit cards, you will be able to get car loans, probably have to pay a little bit higher interest rate.
Right.
The one thing that I have found that I've told people, I don't think that landlords like renting to bankrupt tenants. So I would suggest staying in your current abode for probably at least a year type of thing during and after the bankruptcy. But otherwise, it's a way to, again, it's trying to get these people a fresh start so they can move forward and be productive citizens. So I find that it's a very, very useful tool for our clients in a lot of cases.
Yeah. And it's not like
Minute.
people just, hey, I think I'll file bankruptcy today and get rid of my debts. I mean, you have to qualify. There's the means test and these other things. But the thing is, when you file for bankruptcy, it's because that's your best choice. It's your better option. If you're going to file, it'll be your better option. If that's what you qualify for and you get this fresh start. The whole idea is, the bankruptcy came in, and Rich had said it earlier, it's in the 1700s. Yeah, it's in the Constitution. Article 1, Section 8, Clause 4 talks about bankruptcy. It's been around since our nation was founded. The idea is we didn't want people to go to jail for not, paying their debts. We just want them to pay their debts, and you can get out from under a debt load if you have that issue, if you have that problem. Call Rich, 855-500-TRUST, if you want a consultation with him to figure out whether you would qualify. It's easy to talk to Rich, 855-500-TRUST, get an appointment for him. If you want an appointment with me to review your trust, your estate plan stuff, that's same number, 855-500-TRUST. Rich, again, thanks for being on the show with us today. Appreciate it.
Thank you, Gary. Great to be here.
All right, guys. Talk to you tomorrow here on The Word on Wealth. Bye, everybody.
Tell a friend about the Word on Wealth, featured since 1995, with financial solutions attorney Gary Quackenbush, an expert in estate planning, wills and trusts, and tax problem solving. Gary is past president of the California Society of Tax Consultants. Reach out to us. The Word on Wealth team of financial experts is here to answer your questions and help preserve your family's financial future. The information you hear on The Word on Wealth is for general information purposes only. This program discusses general financial